How does a single social media post cause a federal trial to get completely canceled? And what does it tell us about the limits of government power? Well, we're about to dive into a legal firestorm that all started with just one click.
Okay, so this is the post that lit the match. It's from a senior official at the Department of Homeland Security, Tricia McLaughlin. She went on X, formerly Twitter, and wrote this. So we at DHS are under a gag order by an activist judge, and Kilmar Abrego Garcia is making TikToks. American justice ceases to function when its arbiters silence law enforcement and give megaphones to those who oppose our legal system. Now, this wasn't just some random opinion. This was a public official commenting on a defendant in an active federal case. And let me tell you, the court's reaction was swift.
And this really gets to the heart of the matter, doesn't it? It sets up this huge conflict between two fundamental American principles: the idea of free speech on one hand, and the absolute constitutional right to a fair trial on the other. So where do we draw the line?
So you might be asking, why was this post such a big deal? I mean, people say stuff online all the time. Well, to understand the fallout, you've got to know the rules. There's a very specific playbook for government prosecutors, and it exists to prevent exactly this kind of thing from happening.
It's all about fairness, right? On one side, prosecutors are allowed to keep the public informed. They can talk about the charges, state facts that are already part of the public record, give updates on logistics, that kind of stuff. But there is a very bright, very clear line they cannot cross. And that's anything that could poison a potential jury. So that means no commenting on a defendant's character, no name-calling, and absolutely no opining on whether they think someone is guilty before a trial even starts. These aren't just polite suggestions. These are hard and fast rules to protect one of the most important ideas in our justice system, the presumption of innocence.
This all boils down to a key legal concept: avoiding improper pretrial publicity. The Supreme Court actually set the standard for this. They said that any statement from a lawyer in a case that poses a clear and present danger to a fair trial can be restricted. The goal is really simple. We want juries to make decisions based on the evidence they hear inside a courtroom, not based on some tweet or a splashy news headline.
Okay, so we've got the rules. Now let's get back to our story and see what actually happened when those rules were broken. The consequences here were immediate, and they were pretty dramatic.
Just look at this timeline. You can see the chain reaction, clear as day. Back in October, the judge had already put out a standard order, basically telling everyone, hey, play by the book. Then, on December 27th, the DHS official makes that post. Right away, in early January, the defense lawyers file a motion. And the result? The judge didn't just send out another warning. He took the really extraordinary step of canceling the trial altogether. Instead, he scheduled a special hearing just to investigate the government's conduct. That's a huge deal.
But hang on, because the story gets even more serious. The defense team is arguing that this isn't just about one careless social media post. No, they're leveling a much more powerful accusation, something called vindictive prosecution. They're basically arguing this entire case is an act of revenge.
And the defense team says they've got the receipts to prove it. They're pointing to unsealed emails that they say show local prosecutors were actually taking orders from Main Justice. That's slang for the top brass at the Department of Justice in Washington, D.C. Now, this is potentially explosive because it seems to completely contradict what the government has been saying publicly, which is that all the decisions were made locally. This is the real core of their argument, that this whole prosecution is politically motivated and being run from the very top. And that's exactly what the judge wants to look into at this special hearing.
So why are we talking about this? Why does one case in Tennessee matter to the rest of us? Because it shines a spotlight on something much bigger: the incredible power the government has, and the immense responsibility that has to go along with it.
The entire American justice system is really built on this one simple but incredibly powerful idea. A prosecutor's job isn't just to rack up wins. Their job is to seek justice. They represent all of us, the public, and that means they have a deep, profound duty to be fair, even to the very people they're prosecuting.
I love how one legal analyst, a former federal prosecutor named Harry Littman, put it. He said prosecutors have to give hard blows, but not foul blows. In other words, they can fight tough, but they can't fight dirty. The whole system is built on judges being able to trust that the government is playing fair. And when that trust starts to break down, the very foundation of the system is at risk.
So this whole situation forces us to ask a really tough and, frankly, a really important question. What's the safeguard? What happens when the very people in charge of enforcing the law are the ones being accused of breaking it? Well, as we've seen in this case, the last line of defense is often an independent judge who has the power to hold even the biggest institutions accountable.